Gordon, very nice to see you today. You're in a new
It,
place.
I'm in a new place recording from the home office. I have thought the other day I should mix it up a little bit. Of course, I have multiple recording locations. Have to justify all my tech purchases in some way. But yeah, I thought today worked for that, and so yeah, look, a little bit of a different background, but the same content, and look forward to our conversation today on as part of Estates Made Simple on how to manage insolvent estates. And an interesting topic, because while we're, um, I guess, in an era where typically there's increased wealth, and we've sort of ridden a wave of, especially in Alberta, that people have done well and enjoyed the benefits of the oil and gas industry. By the same token, difficult economic times out there, right? And people have lost a lot of money, and we see higher inflation, and um, financial stresses, right? So that will translate into, well, maybe the estate's not as big as you thought it was, or it's insolvent, right? There's not enough
Mhm.
money to pay all the bills. So I think that's what we're going to talk about today. So maybe, yeah, what are your maybe some introductory thoughts or comments with regard to insolvent estates?
Mhm. Well, and when we think about an estate administration and what the executor needs to do, they really need to follow a path or a list of who to pay first. And I think the important first party to pay are the funeral expenses and the creditors that the deceased had prior to death, as well as any expenses incurred because of death, for example, taxes, because those people need to be paid before any of the beneficiaries are paid. So if there's enough money left over after those creditors, then the legatee beneficiaries can receive their gifts, which is a specific amount or a specific asset. And then whatever's left over, the residual beneficiaries get to share, and that's who's receiving a percentage share. So there's a direct line that the executor needs to follow. And I think it's something to be very, very careful about because if you're paying the wrong people first, you could get into a lot of trouble. So today, yeah, we're going to talk about what expenses are paid first, as well as if the deceased had debts that are not covered with the assets they held, are the debts passed down to the beneficiaries, which is a common question that we get, and we'll answer that through this podcast at near the end here.
Yes, stay tuned for that one. But in those situations, what's interesting is that when you get an insolvent estate, from my perspective, that increases the complexity of that file, right? Because now there are some unique considerations and some enhanced risks, and exposure to the executor that we have to be very careful of. So as you point out, I think, yeah, the we have the costs relating to the pure administration of the estate, right? Um, Before you even get to paying creditors or making a distribution to non-residual beneficiaries or getting a distribution to the residual beneficiaries, we first have to deal with that layer of just the costs of administration. And those have priorities. Those have to be paid first because we don't even get into asking what do we do with the leftover, what
Mm-hmm.
do we do with the residue of the estate until we incur those expenses, right?
Mm-hmm.
So, thankfully, the compensation to the executor to do that work is a priority, and would be covered funeral expenses and the like. Um, the next level would be, of course, the creditors. And that's where there are some more complicated rules. In general, there are certain creditors that may have an enhanced priority over the what's left in the estate. Canada Revenue Agency may have certain claims with regard to taxes that are owing. If GST had not been paid, those are considered trust funds because it's not even the person's money. So we've got to sort those out there, and there may be security, right? If a bank provided a loan for a vehicle, um, they would have security against that vehicle to be repaid that amount of loan. So you've got to sort out who has priority or preference, as far as creditors, and then who has security, and then what about the ordinary creditors, on that. So the executor would need to do a detailed analysis with regard to what is available and how does that get paid. And if there's a contest between the creditors, it may be that an application of the court is required to say,
Mhm.
well, these people are fighting about who's entitled to this money that I've now generated in this estate because I was appointed in this role. Ultimately, you may see an application of the court to sort out technical or contentious issues between creditors. But the point is, you may have to negotiate. So point number one, I guess, with dealing with the creditors is you have to figure out who's owed what, right? And do some work on verifying, is that a legitimate claim, and who's out there. And again, you want to be careful with regard to that. You want to get that correct. It might be not too different in substance to what a trustee in bankruptcy would do if a company goes bankrupt or a person goes bankrupt. Well, who's owed what? People have to submit their proof they're owed the money, and the executor would have to negotiate with the creditors, get all that information, make sure it's a legal debt that is appropriate to put on the list for the distribution to creditors, and then obviously look at some of the underlying documents, whether it's the security documents, review the nature of like, how did this debt arise, to determine if there's preference for that creditor as against the ordinary creditors of the estate, and to sort all that out.
Mhm.
So I think the message here would be, yeah, figure out the facts. You need to negotiate and get the information from the creditors. And if there's room where somebody says, I'm owed this money, you don't just accept it at face value. You got to dig into it. Well, is it supported by the underlying legal documents? Did they add interest that isn't appropriate and not supported by the agreement or the contract? Maybe there's an opportunity to compromise, to challenge that, or to compromise that debt in some fashion. So that can be a significant amount of work, right?
Mhm.
So just be careful. You got to spend the time to do it, and you better, you got to do it well. You don't want to make a mistake on that. Um, and then, sorting out those priorities becomes a big task, and one that requires a certain amount of due diligence. So what I see when clients are going through this is there's a certain amount of stress associated with it, because it's like, well, what if I get it wrong? Or, does that mean I'm responsible? We'll talk about that a little bit later on. We were talking, I think another point that we want to talk about is that, be aware that in addition to beneficiaries scrutinizing what you're doing and keeping you to account, you now have another layer of people who have an enhanced interest in what you're doing and the decisions that you're making and the positions you're
Right.
taking, because they're on a typical estate, it would be, oh, if there's an expense, just pay it, right? Because the money is there to pay it. But what if there's only so many cents on the dollar that somebody is going to get? Well, like, think of you and I, right? If somebody goes, I can't afford to repay you, but I can only pay you this much. Well, you're spending a lot of time thinking about that and negotiating and talking about that person. Well, how much can you pay, and da 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 da. And so just be aware that typically there's on a solvent estate, you don't worry about the creditors, you just pay them.
Mhm.
Unless there's a legal issue involved and you think the person isn't owed the money, but assuming it's a legitimate debt, you just pay it. Nice and simple. But now if you have to negotiate it, they're going to be scrutinizing what you do a lot more carefully, because if you make a poor decision on the administration of the estate, that affects what they end up with. And if it means they're getting something less than 100% of their what they think is the amount that's owed to them, you better believe they're gonna scrutinize it carefully, and they're gonna look for opportunities where maybe you messed up. Um, we were talking beforehand about an example where, well, what if somebody, was too lavish on the funeral expenses? A silly example would be, you have a $75,000 estate and lots of obligations, and maybe say there's $100,000 in debt. Well, yeah, the funeral is going to be paid, but if you spent $50,000 on the funeral on a $75,000 estate, and go to the creditors and say, sorry, there's only $25,000 left, right? Um, you better believe they're going to take a hard look at that funeral expense and say, was that legit? Like,
Mhm.
why did you spend $50,000 on the funeral? Now, most funerals are not 50,000, so I'm making kind of an extreme example to illustrate the point of there's oversight and scrutiny. So be really careful about the decisions you're making for some of those expenses because they're going to come under the microscope, and you want to make sure that they're defensible, because they're going to ask if it seems excessive, and you just don't want to go there, right? That's just going to add to now somebody challenging the decisions you're making. So it'd be appropriate to get some advice on those beforehand.
Well, and I think this highlights the importance of doing that advertisement in the paper, the notice to
Yes.
creditors and claimants. Because if you do have a lot of debts or creditors coming forward, you want to make sure that you have record of absolutely every one of them before you start negotiating and deciding who gets paid and seeking legal advice and doing that process. So it's a couple $100 in the paper, but it's well worth it to save some of your risk as an executor.
Yeah, no, thanks for bringing that up. And that's there's actually provision in the Estate Administration Act to say that if you do that notice to creditors and then distribute, then you would be in a position that you're protected. They can't, and if the estate is distributed and gone and they didn't put a claim in, they didn't respond to that notice, there's enhanced statutory protection for the executor in that circumstance. So it would be really super important to avail yourself of that additional protection, in case you miss somebody. Now, if they come out of the woodwork afterwards and there's still money in the estate, they can claim on what's left over. But yeah, I can't think of a scenario if you have an insolvent estate where you wouldn't do that. Spend the money to advertise in the paper. Um, it's interesting to say there's some discussions about, well, should we do that more efficiently? It's still the old paper, and you got to go like who. Some would say, who reads the paper anymore? Um, that
Creditors do. That's who reads the
well,
paper.
creditors probably do if they're looking for those notices. Um, but yeah, there's some discussion, I'm hearing in continuing education about, well, maybe we should have an online version of those notices to make things more efficient. So stay tuned. There may be changes in these rules going forward, but that's where I'm starting typically on a position of saying, yes, we're going to advertise
Yeah,
for creditors, right? There's a specific provision because I want to access and trigger that protection under the Estate Administration Act, for
absolutely.
the creditors. So that would certainly be quite important to do that. So, Jen, as we said earlier, and I've had it often where, let's say dad, husband passes away. I'm dealing with wife in the office and she goes, oh man, I just found out there's all these debts, and am I responsible for that? Or somebody who says I've agreed to be the executor and is like, holy smokes, there's all this money being owed. Do I need to worry about that? So what's the answer to that question?
Oh, the long anticipated answer. The answer is no. In almost all cases, debts of the deceased do not pass down to children or beneficiaries or spouses unless that other individual had a connection to the debt. So if they co-signed a loan, for example, or if it was a joint credit card or a joint debt in some capacity. But if it's
Or
just a
personal
debt to
guarantee. They may
personal
have personally
guarantee,
guaranteed,
yeah,
like if, mom guaranteed a loan for son to go get, um, do renovations on the house or something,
yeah,
and then son passes away, well, then mom can't say, well, that's not my problem, right? If there's not
right.
enough money in the house to pay for those renovation costs, right? That's an example of where, well, mom, you signed a personal guarantee, you promised to repay the bank, and there's a legal document that says that supports that promise. That would be an exception to the rule. But in
Yeah.
general, yeah, the beneficiaries, an executor is not responsible for the debts. What's interesting, yeah, and that's in relation, obviously, to unsecured debts, because if there's security against a specific asset, like a bank has a mortgage against the house, well, when the house is sold, they have priority to be paid. If a bank has a lien on a car because there was a car loan and security was granted in the deceased person's lifetime, then that may be appropriate. And again, the legal issue there would be check the security. What if the security is invalid, right? So you
Yeah.
gotta check all those things. But yeah, that should be of some comfort. But the other thing that's I think relevant for the conversation is also to say if you're agreeing to be the executor, like you probably want to find out a little bit about what's going on, and maybe you don't have the time or the inclination, or that's keeping you up at night and it's stressful to be dealing with that kind of estate. So maybe you should say, well, I'm not going to do it, right?
Right.
And I had a case a couple of years ago or a couple of weeks ago where it was actually that situation. Um, that family was going to step in and sort of fix up what was a difficult situation, and they go, I don't think we just don't have the mental capacity, bandwidth to do that, right? It's not for us. So they said, well, I think it's going to fall to the public trust office, the public trustee, to clean that up, right? And they didn't want to take it on because it was messy. So, you know, before you intermeddle in an estate, you want to find out what's going on, before you get too far into it. And we had another, scenario. When can you renounce, right? A podcast on that. So that's relevant to also ask the question, well, is the estate solvent? Is there going to be enough money so I can do my job here, and go in with your eyes open if it's an insolvent estate.
Well, I think those are some great comments and great tips for our listeners. So we'll leave it there today. But to all those listening and watching, thank you very much for joining us. We hope you got some value out of the conversation. Please feel free to subscribe on YouTube or on wherever you listen to podcasts. So thank you very much, Gordon, and look forward to our next chat.
Indeed.